Good morning, Dr. Anuradha. Yes, we shall start, Dr. Anuradha.
Right. So just give me 1 minute. I'm streaming live.
Okay.
ஒரு நாளைக்கு நியூஸ் பேப்பர் இல்லை புக் வச்சு 2 பக்கம் படிச்சு பெரிய வார்த்தை கிருஷ்ண வச்சு நம்ம
डॉक्टर अनुराधा कोई किसी का माइक्रोफोन ऑन है, म्यूट कराइए.
Good morning, sir. Am I audible now?
Yes, you are audible.
Okay, good morning to everyone present here, and it gives me joy to welcome all the eminent personalities on day 4 of webinar on IPR Industry Academia Innovative Practices. It is my proud privilege to welcome our distinguished speaker of the day, Dr. Ashwini Siwal, Assistant Professor in IP and IT Law and Director, Entrepreneur Law Clinic, Faculty of Law, University of Delhi, and Dr. Victor Vaibhav Tandon, our principal, Dr. Kiran Angra, who is also an assessment and accreditation ambassador, Paramash, various principals of Menti colleges, my friends and colleagues of Menti colleges, NAC coordinator, Mrs. Nishu Bansal, my cherished IQAC and NAC team, and other dignitaries present here. Dear friends, as we have joined together on day 4 under the umbrella of UGC to reflect the most important feature of NAC, that is IPR, I feel overjoyed, and my gratitude goes to Dr. Angra for giving all of us this wonderful opportunity to organize such an important webinar on Introduction to Indian Patent Law and Emerging Trends and Industry Perspectives on Patents, Scope and Significance under the Paramash scheme of UGC. Today, we are organizing this seminar in collaboration with our Menti Institute, Manohar Memorial PG College, Fatehbad. Thus, I avail this opportunity to introduce our resource person of the day, Dr. Ashwini Siwal. Dr. Siwal is with us since last 3 days, and today also he is one of the resource person, and we all know that he specializes in intellectual property laws, information technology laws, and antitrust laws, and he has research interest in technology and law. And as sir says that we can skip this part because we already know him. So sir, with your permission, if we can start this webinar.
Yes, ma'am. Yes. We should skip this part because I hope the crowd or the audience and the learned colleagues are same, and they know about my education and the rest of the credentials. So there's no need to elucidate or introduce me again. Thank you, Dr. for the kind.
Sir, dice is yours now. I have not hard muted everyone today because some participants said that we have to ask questions. Still, if there will be some disturbance, definitely we have to hard mute everyone. You can put your questions in chat box, and it will always be better that if you ask questions in between or at the end of the session. Right,
good,
sir?
Good. Thank you.
Thank you, sir.
Thank you.
Thank you, sir.
So, first of all, Dr. Anuradha, may I know whether the colleagues who have joined us today are more or less same, or there are new colleagues joining us again every day?
Sir, more or less are same.
More or less are same. Okay.
Right, sir.
So, because I asked this, there is a reason behind it, and the reason is simple, that if the more or less the crowd is same, then I don't need to even recapitulate what we have done so far, in the last 3 days of this interaction. Uh, but for those who have joined us for the first time, let me quickly tell them in 2 minutes time that we started with the introduction of the intellectual property on the very first day, where I took 2 sessions, or club 2 sessions. Then there was the next day, when we were joined by two eminent researchers and two eminent speakers. One from Hero Motocorp, the Hero Motocorp IP Council, Mr. Pankaj Tyagi. He gave us a very excellent presentation on different kinds and different sort of intellectual properties. Same day, we were joined by Dr. Jayant Ghosh, who also took us to the different IP policies for the startups and for specifically for the academic institutions. And yesterday, I gave one session specifically on copyright and the copyright management in the academic institutions in the country. Then we were joined by Dr. Parikshit Sirohi, my learned colleague, who told us about the trademark and the industry perspective on the trademark. Now, today, I plan to talk about patents in detail, and I will be speaking on the different kinds of things on which a patent can be sought and can be claimed, right? Or you may call it what all is protected under the patent regime. You may say that what is the subject matter of the patent in India, right? Then after that, I will be telling you about what are the substantive requirements for obtaining the patent protection. So see, in the initial 1 or 2 lectures, I gave you cursory outlook or outline about the patent system in India. I just told you that inventions are patentable, as well as I told you that it is the process or products which are patentable. But we haven't yet seen what is the subject matter of the patent as specified by the Patent Act in India. Because our law, unlike the law on patents in other jurisdictions, is different in the sense that it provides us with a negative definition, or you may say it provides us with an exclusionary definition. It excludes certain subject matters to be given a patent protection. I will take you to that provision where certain forms of works are excluded to be given a patent protection. There are different sort of premises or reasons for the exclusions or for ousting those things. I would be explaining some of the rationales and the justifications or the policy justifications behind the exclusion of those things. Some of you may say that those things are seemingly, inventions. Still, the Patent Act, by the purview of that particular provision, excludes those things to be given a patent protection. And I would concede with you, I would agree with you on this point. But there is a reason behind this exclusion. The reasons sometimes are social, sometimes the policy, which is based, of course, on the societal things. So there are certain reasons which we're going to learn. Then we will have a look at the substantive requirements for obtaining the patent as to how to obtain the patent. So many of you in the academic institutions are working in different disciplines. Some are from biotechnology, biochemistry, genetics, plant varieties field, or horticulture, you may call, or many from different sciences or other disciplines, who have joined us today. So they all struggle to get the patent protection. So in my 1 hour interaction, I will also be speaking about what are the different policies that have come to help the academic institutions recently in order to fetch the patent protection quickly and at a very cheaper price, right? Or at a very reasonable fee, unlike a normal patent applicant who has to pay a lot of money, right? So we have certain policies in the country. Let's begin with first with the what all things are excluded from the purview of the patent. As I told you in the beginning, and I repeat, that in our country there are things which are excluded, unlike other countries like US, China, Japan, where things are not excluded. They just say that whatever qualifies the patentable requirement will get a patent protection, right? They don't have any list of exclusions, but we have list of exclusions premised on social policies, premised on some or other rationales and justifications. So let us have a look at that provision. I'm going to share my screen with you. Just hold for a moment. Yes, so this will explain, this slide will explain what are the essentials of obtaining patents in India. It is very important for academic institutions to know it. There is a disturbance coming from someone's microphone. No worries, it's fine now. So I was telling you that it is very important for the academic institutions to understand it, that they need to be educated on this aspect. We have this rigid mentality that we don't need to be educated. Once we are the faculty members, we don't require any education on any aspect. Even the people working in the CSIR laboratories, they at times also needs to be educated, right? So that's something which we learn or need to learn as to how to obtain the patents and what are the different essentials. If you look at, I told you that there are some substantial requirements for obtaining the patent protection, and there are some procedural requirements. So I hope that procedural requirements will be taken care of by my co-speaker today, Dr. Victor Weber Tandon, because he comes from the procedural background. He's a patent agent himself. But I will be taking care of the substantive requirements in great detail. So when it comes to the essentials for obtaining the patent, the first and the foremost requirement is that the invention must not have been excluded by the Patent Act as non-patentable invention. As I told you that there is one provision, and it is Section 3 of the Patents Act 1970, which excludes certain subject matters, and those subject matters which are listed in Section 3 can never get a patent protection, irrespective of the fact that they are worthy of getting a patent protection. They are inventions, still they cannot get the patent protection. The reason being that they are explicitly excluded, right? They are explicitly excluded. I can give you one small example. Like, you can't own a patent on human life. If you create a clone today, which will certainly be your invention, right? But that will not get patent protection because of the fact that it has been excluded explicitly by purview of Section 3 under the Indian Patent Act 1970. So is the case of, you can't get a patent on a method of operation or surgical method, for example, right? If you are a doctor, right, and you invent a new method of operating someone, a surgical method, still you can't get a patent protection on that method of surgical operation. The premise, the justification, or the rationale of the exclusion is that it is something which will help the societal welfare, will certainly gonna be like free air to be used or exercised by any doctor in the country to help the patients out. So these are the kind of premises behind the exclusions. So the first and the foremost requirement for obtaining the patent is that your invention must not be an invention which is excluded by purview of Section 3. It has not to fall into Section 3 category, right? So whenever you as a researcher in the academic institution work on something or start working on something, always first refer to Section 3 and take into consideration all the exclusions. And don't ever work into the field where your work will get hit by those exclusions. It is something which will be a smart move on your part. If you will work on something, waste energy and time on something, and tomorrow it will come out as what, or turn out as what, a non-patentable subject matter because it has been excluded by purview of Section 3. So it is unwise, right? So that's the first essential. The next essential is that it must be in respect of a new product and process. The invention will get patented if it is in respect of the new product. The word new has been prefixed here. I will explain what does new mean. New product or process. If the work is not new product or process, it can never get a patent protection. The third requirement is it must involve an inventive step to ensure its non-obviousness. or you may call the work must be non-obvious. If it is an obvious work, you can't get a patent protection. It must involve an inventive step to ensure. What does inventive step here mean? What does non-obviousness here mean? I will gonna explain in detail. But this is the third very important requirement, essential requirement for obtaining the patent protection. The first, according to me, is the work must not fall into section 3. Then it has to be a new product or process, or you may say the emphasis is on the word new. The thrust is that the product or process must be novel, or you may say new. Then the third requirement is that it has to have an inventive step in it. If there is no inventive step, then it can't get patent protection. And the fourth or the last one is that it must have some industrial application to ensure its utility, or you may call there has to be some industrial utility of your work. So these are some of the essential requirements for obtaining the patent. Any researcher in any academic institution, an academic or a research scholar, or for that matter, a young student or any other person involved in any sort of research must first see or at least have a look at section 3, and then later things will be taken care of by the patent office or the attorney and the patent agent who will further pursue his application. But at least the consideration of the exclusions under section 3 is the first and the foremost thing for any researcher. So now I will talk about, what are the patentable subject matters in the country. As I told you that we have a negative connotation or a negative list under section 3, which excludes certain things. So whatever is not falling into section 3 means those things are patentable. Whatever falls under section 3 are not patentable. Any object or thing which are eligible for patent, right? And it has to be an invention only. Not all inventions are patentable. Mind it, as I told you that sometimes you find that your work is an invention, but it has been explicitly excluded by section 3. So no patent will be available to it. The word invention has different meaning in different contexts. I will explain that. Now, if you look at the meaning of invention, the dictionary meaning is one way of defining the invention. Then there is a scientific meaning of the invention. Then there is a legal meaning of the invention. And then there is a meaning for patent protection. And then there is a popular or prevalent meaning of invention or any lay meaning for the invention. Sometimes usually people are found confusing the two terms invention and discovery, but they are altogether different terminologies. Discovery is what? When you discover something which already exists, but invention is altogether different. When you bring something into existence for the first time, a product or a process, it has to be a new product or the process. But what we are concerned here for the purposes of obtaining the patent protection is either the legal meaning or the meaning for the purposes of the patent protection. We are not concerned with the scientific dictionary lay meaning or the popular meaning of the word invention. Legal meaning as provided under the Patents Act 1970 of the word invention, and for the purposes of the patent, again we have to refer to the Patents Act 1970. So these two meanings are the meanings with which we are or we should be concerned about, because rest of the meanings are of no use. Dictionary meaning may be what? Finding something is an invention. Scientific meaning what? Finding solution to something is an invention, but those will not help you in getting a patent protection. When you satisfy the invention legally or for the purposes of the patent protection under the Patents Act, only then you are qualified for obtaining the patent protection, otherwise not. Then if you look at the patentable subject matter, then we have understood by now that it is the invention on which patent is conferred or patent is, granted. It is a government grant which government grants to the person to monopolize or exercise the monopoly accorded to the person for 20 years. So it is an invention on which the patent is conferred. So patentable subject matter is invention as defined under section 2J of the Patents Act 1970, because we have just understood that it is the legal meaning of the invention which is important. Rest of the popular meaning, scientific or the lay meaning is not important for us. So invention, which is defined under 2J, makes the patentable subject matter, which means a new product or process involving an inventive step and capable of industrial application. That is the gist. right? This particular clause, section 2, clause J of the Patents Act 1970 is the gist. It reads that invention here means what? A new product or process involving an inventive step and capable of industrial application. So then section 3 and 4 of the Patents Act provides a list of non-patentable subject matters. Like, as I said in the beginning, that in our country, we have a list of non-patentable subject matters, but on the contrary, in other jurisdictions, they don't have a similar kind of a provision. They just say anything under the sun is patentable. Whatever you create, if it is an invention and if it qualifies the substantive requirements for obtaining the patent, like novelty, non-obviousness, and utility, it can get a patent protection. But in our case, we have also to take care of the exclusion as provided under section 3 and 4, majorly under section 3. So, which I was emphasizing that we have to refer to section 3 always. Then if you look ahead and see, these are some of the provisions which which I would like to skip, because it is not a law class where I need to emphasize on the provisions as such. Now, I would go to what? To the most important part. In nutshell, patentable subject matter equals to what? It equals to product and processes, excluding products and processes mentioned in section 3 and 4. Because we have learned that patentable subject matter is what? Inventions. Invention means what? New product or process involving an inventive step and capable of industrial application, and products and processes excluded by purview of section 3 and 4. वो होगा patentable subject matter in nutshell. ये फलक्रम है इसका. ये जो आपके सामने स्क्रीन पे है, ये एकदम फलक्रम है कि patentable subject matter क्या है. कोई प्रोडक्ट और प्रोसेस, और वो प्रोडक्ट और प्रोसेस नहीं जो सेक्शन 3 और 4 में लिखे हैं, उसके अलावा जो प्रोडक्ट और प्रोसेस हैं. इन्वेंशन जो नॉट पेटेंटेबल हैं, अब देखो व्हाट आर नॉट इन्वेंशन. सेक्शन 3 में फॉलोइंग आर नॉट इन्वेंशन विद इन द मीनिंग ऑफ दिस एक्ट. अब ये जो पोर्शन स्टार्ट हो रहा है, इस पे आपको बहुत ज्यादा एम्फेसाइज करना है, बहुत फोकस करना है. कभी भी कोई रिसर्च आप बिगिन करते हो, यू ऑलवेज हैव टू फर्स्ट रेफर टू सेक्शन 3 सो दैट यू डोंट वेस्ट योर टाइम एंड मनी एंड एनर्जी. बिकॉज यहाँ अगर आपका वर्क कहीं पे फॉल कर रहा है तो कोई चांस ही नहीं है आपको पेटेंट मिलने वाला है, क्योंकि ये चीजें इन्वेंशन नहीं मानी जाती हैं अंडर द पेटेंट एक्ट. वो क्या क्या है? वो कहता है कि कोई इन्वेंशन जो फ्रिवलस है, विच क्लेम्स एनीथिंग ऑब्वियसली कॉन्ट्रेरी टू वेल एस्टेब्लिश्ड नेचुरल लॉज. कोई भी ऐसी चीज जो फ्रिवलस है, जो पेटी है, जो बहुत एडवांस नहीं है, बहुत पेटी है. मैं इसका एग्जांपल देता हूं. जैसे एक यूएस पेटेंट ऑफिस ने एक पेटेंट एप्लीकेशन रिजेक्ट किया, जिसमें एप्लीकेंट ने एक पेटेंट क्लेम लिखा कि मेरा अलार्म मैंने बनाया है, जो अलार्म पंच करेगा इंसान को बिफोर ही gets up, or to make it sure that he gets up on time. So the patent office said that it is a frivolous thing. So we will not give any patent protection to this so-called work of yours because it is frivolous. You may call it an invention, but it is frivolous. और साथ में देखो इसमें ये भी लिखा है anything obviously contrary to well established natural laws. तो कोई भी चीज अगर well established natural law के contrary है, मान लो ग्रेविटेशन नेचुरल लॉ है, उसके कॉन्ट्रेरी कुछ आपने बना दिया, ऑब्वियसली कॉन्ट्रेरी, आप कह रहे हो मेरा ये इन्वेंशन है, आपको पेटेंट नहीं मिलेगा, माइंड इट. या आगे बढ़े आप देखें तो any invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, right? ऐसा कोई भी इन्वेंशन जिसका प्राइमरी और इंटेंडेड यूज और कमर्शियल एक्सप्लॉयटेशन पब्लिक ऑर्डर और मोरालिटी के अगेंस्ट में होगा, इसमें बहुत सारी चीजें आ सकती हैं. क्लोन भी इसमें फॉल कर सकता है. रोबोट्स with the human mind, equal to human mind. I'm not talking about the artificial intelligence embedded into the robots. I'm talking about the human intelligence made robots. तो वो पब्लिक ऑर्डर के कॉन्ट्रेरी है. कोई ऐसी चीज रिसेंटली इंडिया में किसी ने एक टॉय बनाया फॉर सम सेक्सुअल प्लेजर, राइट? दैट हैज बीन रिजेक्टेड अ पैटेंट प्रोटेक्शन बिकॉज इट इज अगेंस्ट और कॉन्ट्रेरी टू मोरालिटी. आउटराइटली रिजेक्ट कर दिया पेटेंट ऑफिस ने. इन्वेंशन होगा लेकिन नहीं देंगे उसके ऊपर कोई भी प्रोटेक्शन. एनीथिंग विच कॉजेज सीरियस प्रेजुडिस टू ह्यूमन, एनिमल और प्लांट लाइफ और हेल्थ और टू द एनवायरमेंट. ये बहुत वाइडर एक्सक्लूजन हैं। यहाँ डिस्क्रिशन बहुत लाई करती है पेटेंट ऑफिस की। कोई भी ऐसी चीज जो सीरियस प्रेजुडिस करेगी ह्यूमन, एनिमल, प्लांट लाइफ को, हेल्थ को, एनवायरमेंट को, ऐसी किसी चीज को भी पेटेंट की प्रोटेक्शन नहीं मिलेगी। आप भले ये बोल सकते हो कि ये बहुत ज्यादा डिस्क्रिशनरी हो रहा है, ये बहुत वाइड है, इसको किसी तरह से भी मैन्यूवर करके डिफाइन या इंटरप्रेट करा जा सकता है। मैं आपसे सहमत हूं, लेकिन इस तरह का प्रेरोगेटिव, इस तरह की डिस्क्रिशन पेटेंट ऑफिस को जानबूझ के दे रखी है, क्योंकि ये एक्सक्लूजन सोसाइटल रीजंस पे प्रेमाइज्ड है। कोई भी ऐसी चीज जो ह्यूमन लाइफ को, एनिमल लाइफ को, प्लांट लाइफ को, हेल्थ को, एनवायरमेंट को प्रेजुडिस कोज करती है या डेंजर या जेपडाइज करती है, उसको पेटेंट प्रोटेक्शन नहीं मिलेगी, भले ही वो इन्वेंशन क्यों ना हो। मैंने पीछे एक स्लाइड में लिखा था कि देयर आर सर्टेन थिंग्स व्हिच आर इन्वेंशन बट स्टिल नॉट पेटेंटेबल। तो ये उस कैटेगरी की सीधे सीधे एक्सप्लेनेशन है कि कोई ऐसी चीज भले इन्वेंशन क्यों ना हो, लेकिन अगर वो प्रेजुडिस करती है ह्यूमन लाइफ को, हेल्थ को, एनवायरमेंट को, नो पेटेंट विल बी कंफर्ड और ग्रांटेड। Then mere discovery, the word mere is used here. You have to notice it, it's noticeable. Only discovery, mere discovery, matlab it is something not becoming invention, just a discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So देखो इसमें तीन चीजें हैं जो यहाँ एक्सक्लूड हो रही हैं। एक तो mere discovery of a scientific principle है, आपने किसी साइंटिफिक प्रिंसिपल का mere डिस्कवरी किया, you will not get a patent protection because that scientific principle existed from before. It is not you who have invented it for the first time. You have just merely discovered it. और इसी क्लोज में mere formulation of an abstract theory. If you make an abstract theory कि black hole है, black hole की मैं ये इस तरह से कर दूंगा, वो कर दूंगा, abstract theory है, visceral कुछ नहीं है उस पे concrete कुछ नहीं है, you will not get a patent protection on that theory or on formulation of the theory. Similarly, you don't get a patent protection on mere discovery of any living thing or non-living substance occurring in nature. Any living or non-living substance occurring in nature, मतलब वो आपने discover किया, आपने invention नहीं की. If you have invented it and there is some human intervention in inventing it, then you may get it. Microorganisms are patentable, but only man-made microorganisms are patentable, not the discovered microorganisms or living things or non-living substances. Similarly, इसके बाद देखो any thing that you discover or any new form of something which you discover or of a substance that you discover which does not result in the enhancement of the known efficacy of that substance. I have an example to explain this clause also. This is a very famous clause, section 3 clause D. If you have heard about the Novartis case, where Novartis even went to the Supreme Court, right, challenging the non-grant or non-conferment of the patent protection on their so-called inventive drug, right? They discovered a drug for treating the patients of leukemia, or you may say for treating the patients of blood cancer, and they had a patent on that very drug in many jurisdictions of the world, right? Even in India, they had a patent on the same. But that particular drug on which they sought a patent and they got a patent and they enjoyed and exercised the patent was about to expire. So they brought what? A new form of the same, which was a beta crystalline form of the imanitin mesylate. If there are science people, they may understand. They brought a beta crystalline form, right, of the imanitin mesylate, and they sought a patent protection, a fresh patent protection on the beta crystalline form of the imanitin mesylate. The patent office said, no, we will not give you a patent protection because it is just a new form of the known substance. There is a known substance called imanitin mesylate. What you have done now, you have just brought a new form that is a beta crystalline form of the imanitin mesylate for treating the blood cancer patients or for stopping the progression of their diseases, right? But this is not something which is bringing enhancement in the known efficacy of that substance. So the court said that had there been the efficacy, had there been some improvement in the beta crystalline form, we would not have mind to confer a patent protection. But since there is no enhancement in the efficacy on the non-substance or on the existing substance, we can't give a patent on this beta crystalline form, or you may say on this uh, new form of the non-substance. This particular provision is used by the patent office to stop the practice of evergreening. You might have heard about the abuse of the patent that is called evergreening. People, multinational companies, pharmaceutical companies, they usually do what? They bring one form of the particular composition, they get a patent, they enjoy the monopoly for 20 years. When they are done with the monetization of the same, they bring a new form by tinkering a little bit with the earlier form or the existing substance, and they seek a separate or a fresh patent on the same, just to keep it green forever. The patent office, the law says no, you can't do this. Evergreening of the patent is not allowed. This is an abuse. This is not an use. So the court in this Novartis case, this case is Novartis versus Union of India of year 2013, said that we will not confer a patent protection on the beta crystalline form because it does not have the adequate enhancement in the efficacy. And here, enhancement of the efficacy was interpreted as a therapeutic efficacy. Though they tried to prove that we have a therapeutic efficacy, this particular beta crystalline form or the new form is more soluble, or you may say more efficient in terms of reaching to the particular cancerous part of the body. But the court said no, it does not bring any therapeutic efficacy. What we need is the therapeutic efficacy. It may be a change in the administration of the drug, for which you are calling a enhancement, but we are not concerned with the mere administration or the new mean or way of administration of the drug. We need a therapeutic efficacy. How efficacious the new form is in treating the disease vis-a-vis to the previous form. This is what we require. A data on the same we require. In this case, Novartis failed to procure the adequate data, and court had to turn their request down. And ultimately, they were not conferred a patent protection on the same. So this is very important. If you have research interest in this particular field, kindly always bear in mind that you can't just get a patent on a new form of the non-substance unless there is a enhanced efficacy in your new form. Then we have remaining clauses or exclusions. इसमें साथ में ये भी है कि salt, esters, polymorphs, metabolites, pure form, practical size, isomers, they are what? They are just the derivatives of the non-substance. So unless they differ significantly in their properties with regard to efficacy, they are not considered as patentable subject matters, right? Because they are just the new form, or sometimes isomers or esters, ethers, etc., right? Then we move ahead with some other exclusions. A substance obtained by mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. If I mix, say, wine and soda, I just do what? I am doing mixture of two things, which is not resulting into any new component. It is just the aggregation of the properties, original properties of wine on the one hand and the water on the other hand. So any substance which is obtained by mere admixture will not tantamount to a patentable subject matter. No patent can be conferred on the same. Then we have the mere arrangement or rearrangement or duplication of known device, each functioning independently of one another in a known way. If you arrange certain things, rearrange certain things, or duplicate certain known devices, each functioning independently of one another in a known way. I mean, by arrangement, rearrangement, you have not brought a new functioning to those devices. Each device is functioning in its independent way, even after the rearrangement, arrangement, or duplication. So you have not done anything which will be called invention. You can't get a patent protection again on mere rearrangement, arrangement. You mix two things, bring them together, each functioning independently. I tell you, right, an example. You have a bottle, right? You have a spray cap, right? You put the spray cap on a bottle. Mere arrangement of a spray cap on a bottle does not entitle you for any invention here, because each thing functions independently. Bottle functions to contain the liquid or to hold the liquid in it. On the other hand, spray dispenser works to dispense the liquid. That's it. Each functions independently. If you bring them together, it does not bring any invention into the existence. So you don't get any patent protection on such kind of a work. और इसी के बाद देखो, then we have a method of agriculture or horticulture. You don't get a patent protection on any method invented by you, even if you have invention in the field of agriculture and horticulture, right? There may be a possibility where you have invented an agricultural method, you have invented an horticulture method, but you can't get a patent on that horticulture method or agriculture method because it is excluded explicitly by purview of section 3 clause G, and the premise is that agricultural methods, horticulture methods are allowed to be used by everyone. But if you have come out with a plant variety, being a farmer or being a plant producer, you have certainly another regime called Plant Varieties and Farmers' Rights Act of year 2001, where you can get a protection on your plant variety, which may be an extant variety created by you, right? Then a method of agriculture or horticulture, as I said, it is repeated here. Then we have any medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human being, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. Even that is not patentable. You can't get a patent on medicinal method or any medicinal process, or any medicinal, on any surgical process or any curative process or any therapeutic or other treatment of human beings, because the law says that there is a reason, that there is a justification or there is a rationale behind it, that those surgical methods or medicinal methods, curative methods, therapeutic methods or processes are like free. They are required to be used or to be utilized by every individual. They must not be given into monopoly to one single individual who claims to be an inventor or a person who have come up with this process of surgery or curative method or a medicinal method. If today I am being a surgeon, say suppose I am a orthopedic surgeon, if I invent a new surgical process, I won't get any patent protection on that surgical process. Even if suppose I'm a medicinal practitioner, if I come out with a medicinal process, I can't get a patent on the medicinal process, so and so forth, right? These are some explicit exclusions premised on social policy and social reasons. Then plants and animals in whole or any part thereof are also not patentable. Any plant you produce, you can't get a patent on the plant, but you have certainly a option of going under the Plant Varieties Act if your plant is an extant variety which you have created. You can't even get a patent protection on animal or any part of plant or animal thereof, because that is again a social policy. But microorganisms are patentable, because this is the only positive thing in the whole section, that microorganisms are patentable. It is written other than microorganisms, means microorganisms which are non-naturally occurring, which are there because of the human intervention, are patentable. Seeds are not patentable. Varieties and species and any biological processes for production or propagation of plants and animals are also not patentable. So this is categorical exclusion of certain things. If you tomorrow create a seed or a specific variety and species of a seed, or essentially biological process of reproduction, right? Or for the propagation or production of plants and animals, you can't get a patent protection on the same because explicitly excluded. Then a mathematical or business method or a computer program per se. Well, this is our next, this is another exclusion. Any mathematical or business method. If you today come out being a mathematician, you bring some new method of solving certain complex mathematical problems. You can't get a patent protection on mathematical method. You can't get a patent protection on business method in India. In US, business methods are patentable, but in India, business methods are not patentable. I have an example of business methods, like Coca-Cola has its own trade secret still on what? on their particular composition with which they make this, tasty beverage. Unhealthy maybe, but tasty beverage, right? This is a business method that they have, and they don't disclose it because they have a trade secret as well as a patent protection on it. Usually they apply for the trade secret protection, or they keep a trade secret protection on such peculiar complex methods, because patent method or patentable method, business method will have a life of only 20 years till the time patent is operative. Once it comes into the public domain, the patent on the same will expire and it will come into the public domain. But what these smart entrepreneurs usually prefer to do, they keep the trade secret protection, which have no time duration or time, confines. It is available with the creator or with the person owning the trade secret forever, right? There is no limitation in terms of duration. So usually they get a trade secret, or keep a trade secret, but business methods are patentable in US, not in India. Then computer program per se, as I told you that computer related inventions are patentable, but computer program per se is a literary work which falls into the category of copyright, and a copyright protection can be sought on computer programs per se. Computer related inventions, if there are any, then they may find a scope of getting a patent protection, but not the computer program per se, which is not patentable in India. It is copyrightable in India. Software patents in India are not allowed, but now there has come a little momentum on granting computer related inventions or some software patents in India. So we are seeing a change, or you may say a shift towards the software patenting in India. Then any literary, dramatic, musical or artistic work, or any other aesthetic creation, including cinematograph works and television productions, they are not patentable subject matters, because literary work gets a protection under copyright law, dramatic work, musical work, artistic work, aesthetic creations, they all get a copyright protection under the copyright law. So these are the works which are protectable under separate kind of IP called copyright. So they are not allowed to be protected here under the Patents Act. Then we have another category, mere scheme or rule or method of performing mental act or method of playing game. Today, if Dhoni says that I need a patent protection on my helicopter shot, it is just a method of playing game. He can't get a patent protection. Even if it is something specific and unique of him, but he can't get a patent protection on the same, because it is excluded by this particular clause called 3M of the Patents Act. Similarly, method of performing mental act. If a magician today says, I need a patent on my method of performing a mental act, I am a magician, I do mental acts or I perform mental acts, he can't get a patent protection. Similarly, a mere scheme or rule, of performing mental act or any game, like योगा के ऊपर पेटेंट डाल दिया एक इंडियन ओरिजिन का योगा एक्सपर्ट था यूएस में, यूएस born but originally Indian. He had his own unique yoga on which he sought a patent protection from the United States Patent Office, but he was denied the patent on the yoga because this is just a method of performing something or playing a game. Then a presentation or information. If I am presenting in front of you, I can't claim that I need a patent on it, but I certainly have a copyright protection on my presentation or on the information which I'm presenting. Any topography of integrated circuits are not patentable because there is a separate legislation which is called Semiconductors and Integrated Designs Act, under which integrated circuits or topography of the integrated circuits are protected. Any invention which in effect is a traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components, not patentable. We all know that traditional knowledge is something which lies with us, is with us, or have been with us for long or for the time memorial, right? We all in the household use haldi because we know that it has some therapeutic value. It heals some diseases, or sometimes, we use certain plants for healing the wound or healing some other aspects, or any traditional knowledge for that matter. There are people in the northeast who use the plant leaves to make the paintings. That is their traditional knowledge, right? There is a tribe in Chhattisgarh which makes the paintings with the natural leaves or having the colors, natural colors basically. So that is their traditional knowledge. So that kind of a work can never be called an invention, and it is not patentable. Then there is section 4. I told you that section 3 and 4 excludes certain things. Section 4 excludes the any kind of an invention related to atomic energy, or falling under section 20 of the Atomic Energy Act 1962 in India. So any invention relating to atomic energy can never get a patent protection, even if it is an invention. Today you are an atomic scientist, you create something. Dr. APJ Abdul Kalam created several things, but he could not get a patent protection because section 4 says that atomic energy related inventions are not patentable. Exclusion hai specifically or categorically or explicitly. So I would like to pause here for a moment and interact. If there are any questions from the audience, let me first interact with you and see if there are any questions relating to whatever I have presented so far, because I hope that these things must have triggered some sort of questions in your minds, and you must be by now thinking that there are several exclusions. So what all is patentable? I said that whatever is not falling into this category is patentable. So you have to be very careful that there's nothing which is relating to horticulture or method of agriculture or performing a game or mental act or mathematical solution or surgical method or prophylactic method or curative method. These are excluded things. Anything beyond these things are certainly patentable for sure. You can get a patent protection on remaining things which are not explicitly excluded by purview of section 3 and section 4 of the Patents Act. So this is what I wanted to tell you so far as the patentable subject matter is concerned. After that, I come to the next portion, if there are no queries, where I would be covering or talking about the remaining elements for obtaining the patents, and those are the technical requirements, or you may say basically you may call those are the substantive requirements for obtaining the patent protection. In the very first slide, I have shown you that there are some more requirements apart from the exclusion of section 3 and 4. What are those? That the work has to be new product or process, which means there has to be a novelty in your work. If there is no novelty, you can't get a patent protection. So what does novel mean for the purposes of the Patent Act? It is also very important for you to understand. Well, novel for the purposes of the Patent Act means anything which has not been anticipated before, which has not fallen into the public domain, which has not become a common thing in the public, or which has not been in use anywhere in the country or elsewhere in the world. So what happens, my dear colleagues or learned colleagues, when you apply for the patent protection, you get a patent protection territorially, but the patent search to negate your patent claim is done globally, right? If they find any single claim similar, resembling, or identical with your claim, they say that your work is not novel because it is a work which has been anticipated somewhere in the country or elsewhere in the world, or it is in use in the country or elsewhere in the world, or it has come into the public domain, right? Though there are exceptions to this rule, like sometimes being scientist, you have to go to the exhibitions and showcase your work to fetch some fundings, grants, etc. That is something which is not an anticipation for the purposes of the Patent Act. You get an exemption, and it is advisable that you file a priority application always, because when you go for the exhibition, sometimes some other researcher of the similar field may take a cue from your work and create a work earlier than you and go to the patent office and seek a patent protection, right? So it is advisable that you always file a patent application first. If you think that your work is worthy of getting a patent protection, it is not something which is explicitly excluded by purview of section 3 and 4, as we discussed just now, and which is novel according to you, which is non-obvious according to you, and it is of utility according to you. You must go ahead with the application. And those things like, exhibitions or showing or showcasing them later, or if let me take an example. Today, the company does a test, use of something, like some shoes have been invented by the shoemaker company for the purposes of, facilitating a sprinter to to run very fast. उसान बोल्ट को कोई शू बना के दिया कंपनी ने, उसान बोल्ट ने पहना और वो भागा. तो अब क्वेश्चन ये है कि क्या इन यूज आ गया वो, बट क्योंकि वो टेस्ट यूज के लिए डाला गया था और किसी ने अगर आइडेंटिफाई भी कर लिया तो भी वो एंटिसिपेटेड नहीं माना जाएगा. कल को पेटेंट एप्लीकेशन होती है तो वो नोवल वर्क माना जाएगा, राइट? उसको कहोगे कि नोवल है. नोवल्टी कैसे चेक करी जाती है? पेटेंट सर्च करी जाती है, और पेटेंट सर्च में जो आपकी क्लेम होती है उसी क्लेम के, ड्राफ्ट क्लेम के कीवर्ड्स पिक करे जाते हैं. आपने बनाया अ शू टू फैसिलिटेट रनर्स, राइट? देयर इज सम इन्वेंशन व्हिच यू peculiarly attribute to those shoes. Now the question is, how would you draft your patent application for getting the patent protection? The patent agent is required to draft your patent application, because you, being the inventor or an expert of the field, can't draft the patent application, because patent agents are more well versed in and experts of the field. But you will certainly help them in telling them the technicalities or the technical information about the patent that you seek. But it is to be drafted by the patent agent, so that the draft is made in such manner, or the claim of the patent is made in such manner that it is neither too wide nor too narrow, right? This is the strategy that the patent agent or the patent applicant needs to always follow. Their claim should not be too broad or not too narrow. If there are disadvantages in both the cases. In the case of broad patent claim, the disadvantage is that the patent search will be conducted according to that broad patent claim. On the contrary, if it is too myopic, then your patent claim will only be considered only for the myopic or for the narrow claim, not for the reasonable things which are likely to get covered in your patent claim. And tomorrow nobody else will be able to monopolize or use those things for next 20 years. So it is a strategy that needs to be opted by the person filing the patent, along with the help of the patent attorney and the patent agent, that neither the too broad claim nor the too narrow claim is to be filed. And it has to be seen that it is a claim which, because of being too broad, will not get hit by the requirement of novelty. If it will be too broad, it will have too many information in it, or you may say too many keywords in it. In the patent search, those keywords will get picked up by the patent search tools, patent search databases with the patent offices, and automatically they will say, look, your patent claim is resembling with this particular X patent claim which we have found, and this X claim is anticipated, is already patented, is already in use, is already anticipated in another country or in the country in India, right? So these are some of the things which you need to always be careful of. Apart from that, the next requirement is non-obviousness. Somebody has asked me to share the screen, but let me tell you that I have the screen for the same also, but I have not opened that particular PPT. So I am just telling you things extempore so far as the requirements for obtaining the patent is concerned. The second requirement is non-obviousness. Well, non-obviousness is very strenuous requirement. Seema Agarwal is asking to unmute herself. Dr. Anuradha, kindly unmute herself. I would like to take her question if there is any.
Sir, she can unmute herself. I have not hard muted anyone.
Okay, okay. No, she's not asking. It is a misunderstanding on my part. Well,
Right, sir.
Okay, so the point is, the next requirement is non-obviousness. There has to be a inventive step involved in your work. In India, we use the word inventive step. We don't have the word non-obviousness. In US, they use the term non-obviousness, which is synonymous with inventive step in our legislation. Similarly, in India, we use the new product or new process. We don't use the word novel. In US, they use the word novel. So in our literature in India relating to patents, in our court judgments also, one may find the word use of the words novel, non-obviousness, because we find that there is no difference between these terminologies. They are synonymous of one another. It is just for the sake of brevity of expression, for bringing the euphony, they use interchangeably these terms. So non-obviousness means what? Inventive step. There has to be an inventive step in your work. Inventive step has been defined under our legislation as what? That inventive step is either the technological advancement in your work or some economic significance in your work vis-a-vis to the earlier work, right? That is how it has been defined. Technological advancement or economic advancement, which is something discernible, comprehensible by the person skilled in the, so which is not discernible or comprehensible by the person not ordinarily skilled in the art. There has to be some such you may say attribute in your work. There has to be some such peculiar characteristic in your work which is not comprehensible or discernible by the person ordinarily skilled in the art. That makes it non-obvious. Let me give you an example. If you come out with a work today which you call an invention and you seek a patent protection, and your particular application for the patent protection has already been qualified for the novelty, the next step on the patent office or at the end of the patent office would be to check its non-obviousness, whether it is having non-obviousness or not, which means that they will look for the technical advancement in it, either the technical advancement or the economic significance or both, right? And they will see it from the perspective of the person ordinarily skilled in the art, which means that they will see it whether the particular person ordinarily skilled in the art would have done the same thing had he been assigned this work or had he referred to these many prior arts. Like let me give you a very elementary example. Today we go to a ordinary mechanic, right, who is a skilled person in repairing things. It's a very elementary, very crude kind of an example to make you understand the requirement, the substantive requirement of non-obviousness. You go to an ordinary mechanic, he is not specialist in fixing the punctures in the tire or in the tubes, but you go to him, you provide him with the adhesive, you provide him with the tool for fixing the punctured tire or something, right? By just taking help of the several tools and the available knowledge with him or the skill set with him, he would be able to fix it, right? So tomorrow if somebody say that it is me who has only invented this particular thing of fixing the tires or fixing the punctures in the tires, right? He can't get a patent protection. His work may be novel because no prior art hitting the same or negating the same is available as such, identical available as such, but there are multiple prior arts from where the cue can be taken, and an ordinary person skilled in the art like an ordinary mechanic can claim that, look, if I had been given this particular punctured tire with those tools, I would have also fixed it, right? So it is something obvious for the person skilled in the art. So anything which is obvious for the person skilled in the art is not patentable or can't be given a patent protection. We need to have something non-obvious or having an inventive step in it. This is a most strenuous requirement because in this particular requirement, multiple prior arts are referred. We also, in the patent law, we have a concept of mosaic, right? Mosaic means what? Mosaic क्या होता है? Mosaic होता है जहां बहुत सारी चीजें, कलर्स मिक्स करके कोई चीज दिखती है, right? मोजाइक उसको बोलते हैं. जनरली हमारे घरों में पहले ना आर्टिफैक्ट्स होती थी, मोजाइक आर्टिफैक्ट्स होती थी, जिसपे बहुत सारी कलर्स और बहुत सारी पेंटिंग्स होती थी, उसको मोजाइक बोलते हैं। तो ये एक तरह का ये है कि कोई आदमी मल्टीपल रिसोर्सेज को रेफर करके मोजाइक क्लेम लेके आता है, मोजाइक क्लेम। वो कहता है कि देखो जी ये क्लेम है मेरा और मैं इसमें पेटेंट चाहता हूं। वो सिंगल कहीं प्रायर आर्ट में तो नहीं मिल रहा एज सच, उसने नाम दिया उस क्लेम को एक्स, वो एक्स सिंगल आर्ट में तो कहीं नहीं मिल रहा। लेकिन जब उसकी इन्वेंटिव स्टेप चेक करेगा पेटेंट ऑफिस, तो वो मल्टीपल प्रायर आर्ट्स रेफर करेगा, ए बी सी डी, कहीं कोई चीज पब्लिश हुई है, कहीं कोई चीज यूज में है, कहीं कोई चीज पब्लिक डोमेन में है, उन सब चीजों को रेफर करके वो देखेगा कि इस इन्वेंटर के क्लेम में ऐसा लग रहा है जैसे इसने सारी चीजों को टुगेदर रख के मोजाइक क्लेम किया है बस, है ना। तो उसको पेटेंट नहीं मिलेगा इसके ऊपर, क्योंकि वहां नॉन ओबियस नहीं है वो वर्क। किसके लिए नॉन ओबियस नहीं है? पर्सन स्किल्ड इन द आर्ट। इंडिया में ऑर्डिनरी वर्ड भी यूज नहीं हुआ है, यहाँ कहते हैं पर्सन स्किल्ड इन द आर्ट। तो इसका मतलब उसको पेटेंट नहीं मिलेगा, क्योंकि वो काम कोई पर्सन स्किल्ड इन द आर्ट भी इजिली कर सकता था। असेंबलेज की उसने, एक तरह से अरेंजमेंट की चीजों की, वहां ओबियसनेस नहीं, नॉन ओबियसनेस नहीं है, वहां इन्वेंटिव स्टेप नहीं है, वो ओबियस वर्क है। ओबियस का मतलब ही क्या होता है कि ओबियस है, ये तो मैं जानता हूं, ऐसा तो मैं भी कर देता। उन चीजों को रेफर करके, फला एक्स किताब पढ़ के, वाई प्रैक्टिस देख के, जेड की डिस्कोर्स सुन के, है ना, जी की पर्टिकुलर इक्विपमेंट को देख के ये काम मैं भी कर देता। तो ये जो रिक्वायरमेंट है ये सबसे स्ट्रेनवस है। आई बिलीव डॉक्टर विक्टर हैव आल्सो ज्वाइंड अस and we are very lucky to have him with us here. He is a patent agent and a patent attorney with Sai Krishna and Associates, and his experience in defending the patent claims, in aggressively pursuing the patent battles in the courts in Delhi and in Supreme Court and High Court of Delhi is very vast. So we are fortunate to have him with us. Victor, are you listening us? Victor, he joined us for a minute ago or so. Let me check. But the point that I want to convey is this is the second substantive requirement. Yeah, Victor. So
Dr. Shiva,
I was saying that we are fortunate to have you here, Dr. Victor Vaibhav Tandon.
Just a second, Shivalji, there's just one slight thing. My matter is the very next one, so I can do either of two things. I can start and then pause for 10 minutes, or maybe you can continue. I was listening to you in the last few minutes. You were explaining about inventive step, was wonderful. So maybe you can continue for another maybe 10 to 15 minutes, and then I will log in back.
Okay, no issues. I will engage the audience for next 10 minutes. Don't worry.
15-20 minutes.
But you please wrap up your matter in 10 minutes.
I am in my lordship's hands. I can't commit, but by 12 o'clock I should definitely be able to join. I will just arrange the system also.
Okay, fine. You go ahead. 12 o'clock will be too late. We request you to kindly.
Let me just see how it pans out. I will see if I can maybe take a 5 minutes break in between. It's just a 5-10 minutes matter. But the matter before us is stuck right now. मैं देखता हूँ. आप please continue करो. You can continue.
Whose lordship's court is it, if I may ask? Whose lordship's court is it?
Justice Jayant Nath.
Okay, Jayant Nath. You carry on. Best wishes. So this is what this is about the second substantive requirement for obtaining the patent. The third is utility or the industrial application. The third and the last one is utility. So your work has to have what? Some utility. If it is of no utility, no patent can be conferred. Though, unfortunately, this requirement is not given much importance by the patent office. They usually go with the, you may say, assumption that your particular work will be utilized after getting the patent protection or after conferment of the patent protection by the inventor or by you, basically. But mind it, there are certain corresponding rules where working is the periodical assessment is done by the patent office. Like there is a form 27 in patent rules, right, which requires the inventor or the patentee basically, who has already got a patent protection, to furnish the details of the working of the patent on an annual basis. But this requirement is a new requirement which was brought last year only, sorry, in year 2019. But now this requirement has been diluted a day ago or 4 days ago, when we were we had new patent rules of 2021. On September 21, we have the new patent rules announced, where this requirement of furnishing the working of your patent annually or periodically in Form 27 has been done away with, or has been diluted to a very great extent. And Victor will also concede with me on it, that now that requirement, which was a bone of contention for the multinational companies and for the inventors in India, because it is not easy to provide the details of the working of the patent every year to the patent office, right? And there is a petition which actually brought this change in the High Court of Delhi. This petition was filed by one of the professors long ago, where he showed the details of the working of the different patents conferred by the patent offices. As I said, that utility, the third substantive requirement, is not given much importance and much heed by the patent office itself. This is something which lies only on the paper. But the professor filed a public interest litigation, a PIL, and he showed a detail from the patent office, where the High Court gave the directions to the patent office to procure those details of the working, and they miserably failed in providing the details. They said, we don't have any statistics or data available with us. So the court said, no, you will have to provide the data. And the court also directed the concerned ministry to frame rules where annual data furnishing is to be made mandatory by the patentees, right? And then patentees started making hue and cry, and they started lobbying against the government new rule or Form 27, right, where the details were to be furnished. Actually, there were certain complex issues and the technical problems behind it. If I may explain to you, first and the foremost is, patentee usually does not work with the patent. He licenses it to the licensee or assigns it to the assignee, who actually industry applies it. So usually the patentee is not able to furnish the information. He will have to rope up the patentee or the licensee or the assignee in that case, and seek the information from the assignee and the licensee. Or sometimes the patent is licensed to multiple agencies, right? It is not an exclusive patent done to one individual. Multiple players are given a patent protection. So the patentee has to seek the information, or the Form 27 has to be filled by the multiple players who are the licensees of that work or the assignees of that work. So it was little, procedurally very tough to gather or collate that much of information in a year's time and to furnish every year to the patent office. That's why after the hue and cry of 2 years and a strong lobbying done by the industry, in year 2021, 5 days ago, this rule has been relaxed and diluted to a very great extent. So this is all about the substantive requirements for obtaining the patent. After that, we come to what are the different forums, the platforms available for the academic institutions to start with, in the case of in the case of filing the patent, or if they are interested in filing the patent protection, etc. So for that, let me tell you that there are several such platforms, like IP facilitation centers are now operative in states. Yesterday we got the information from one of the speakers that there are 24 such IP facilitation centers operative in our country, right? Each state is mandated to do so, but some of the states have collaborated with the IP facilitation centers of the other states. That's why we have such 24 IP facilitation centers. Then we have patent facilitation centers by the concerned Department of the Science and Technology of the state ministries, right? They facilitate you to file the patent, etc. in your they also facilitate you in drafting your claims, in helping you out in filing your patent application to the concerned patent office, etc. Apart from that, as I said, that there has come new rules yesterday only, And the major attributes, or you may say the attractive changes in the new rules are that the new rules basically simplified, first of all, the compliance procedure of Form 27, which I just mentioned. पहला काम तो ये किया है कि कंप्लायंस का जो है ना फॉर्म 27 में डिटेल देना वर्किंग का, उसको स्टार्टअप्स के लिए और एजुकेशनल इंस्टीट्यूशंस के लिए स्पेसिफिकली दो कॉन्टेक्स्ट में, स्टार्टअप्स एंड एजुकेशनल इंस्टीट्यूट्स के लिए उसको सिंप्लीफाई कर दिया है. इंडस्ट्री के लिए आज भी नहीं किया है, बट स्टार्टअप और एजुकेशनल इंस्टीट्यूशंस के लिए फॉर्म 27 की कंप्लायंस बर्डन रिड्यूस कर दी गई है. साथ में रिडक्शन करी है इन दी फी फॉर स्मॉल एंटिटीज. अब फाइलिंग और प्रोसेसिंग फ्यू है ना जो वो 80% रिड्यूस कर दी है फॉर एजुकेशनल इंस्टीट्यूशन, विच इज अ रिमार्केबल स्टेप. आप अगर देखेंगे जो फी पहले जो फी पहले कभी ऑलमोस्ट, Victor, correct me if I'm wrong, according to me the fee used to be some 41,000 rupees or something for filing the patent, right? But now because of the 80% reduction in the filing and processing fee for the educational institutions, it has drastically decreased to some 8,000 rupees. And that 8,000 rupees is also, sometimes monetary help or fund is given to you by the patent facilitation centers, and they do it for free. Then, similar reduction for startup and small entities in design applications is also the, attribute or the, you may say, attractive feature of the new patent and design rules, which we got on September 21, 2021. Yes, so this is all from my side because Victor has joined us and he would like to take a break whenever his matter will come. So he is perhaps logged in with the two devices, one in the Lordship's court and another with us. So without wasting time, I would invite Dr. Victor Tandon because he may have to immediately take a break in case his matter is listed in the Lordship's court. Victor, you please speak. We will give you an introduction quickly. I will take the opportunity, Dr. Anuradha.
Right,
Victor
sir. Thank you so much, sir.
Victor is very dynamic colleague of mine. Victor is doctorate in law, and he is a gold medalist in his masters from a very prestigious institution called Indian Law Institute. And Victor basically, is a patent agent and a science student. Victor has been a law faculty also at one of the prestigious institutions, that is Rajiv Gandhi National Law University, Patiala. Then, because of his romance for litigation or patent, practice, he quit his teaching, and now I am seeing that he is aging because he has left the teaching. Teachers don't age; it is the lawyers who age. You are aging; you have to take care of your health. With the best wishes, I leave the forum in your hands, Dr. Victor. Over to you.
Thank you, Dr. Siwal, for that lovely introduction. And yes, aging because of, I think, the stress, which is very amusing. I was not aware this matter just turned up yesterday evening. I'm sorry, I'm still dressed for the court. And as Siwalji said, that I might just have to take a 5-10 minutes break to whenever our matter is called. Another matter just before us has stuck for the last half an hour. Anyway, so I will start. Is there a possibility of sharing screen? Yes. Okay. Can you see the screen?
Yes, sir, it is visible.
Victor, I have already told the basics of the patent. I would request you to kindly give us the perspective as a patent agent and, as a patent attorney and practitioner, the challenges that you face and the specifically the context of the, people coming from the academia, what kind of, the challenges that you find into their respective applications. This is what
Right.
I believe will make sense here.
Right. So starting with academics or starting with any client, anybody who comes to us for patent related work, especially from India, there are a lot of myths, there are a lot of misconceptions, and most of our time in the beginning, at least, especially with academicians, even from DU, from other technological universities, is spent in doing away those myths, those misconceptions. So many people, for example, would come to us and say they want a global patent. I'm sure Sivalji must have touched upon some of these topics. So the idea is that whenever I now go to these kind of webinars, seminars, conferences, there are two things that I focus on. One is this clarification of certain myths and presentation of certain facts. And the second thing, which I will shortly come to, is why are we engaging in these exercises? Why do we want our academic institutions or our Indian companies, Indian businessmen, small and medium-sized enterprises, SMEs, or startups in India to take up this IPR? Patent is just one aspect of IPR, as you might have known by now. So, but why do we want this? Why all of a sudden today, or since the national IP policy of 2016, we are giving this emphasis, this thrust that let us have IP awareness. So I'll just come to that aspect also in a moment, and then I will quickly take you through the procedure for filing the patent application and obtaining a patent. So these three parts is what I have divided my presentation for today into, and this is what I propose to do. Now, first thing is, as I said, many people come to us and say that, okay, we want a global patent, or I want to apply for a patent application and I want to have a universal patent or a protection world over. Now, this is not possible. You can only get a patent, or for that matter, any kind of intellectual property protection, only in the territory where you have applied for. So you have to apply for a patent or a trademark or a copyright in a particular country, in a particular territory, and you are going to get protection only in that territory. There could be procedures. I will not go into those because they are slightly more complex, but there are procedures, there are possibilities that you can file a global or a international application. But even if you file an international application, there are trademark applications, patent applications, there are treaties for that. Even if you file those kind of applications, still the task of granting a patent to you would fall upon the respective IP offices, on the respective patent offices. They are the ones who are going to examine your patent applications and grant your patent, number one. Number two, as you might have already learned by now, and as Dr. Sival rightly pointed out, simply filing a patent application does not mean you will get a patent as well on it. There is a whole procedure which a patent application, a patent applicant has to undergo before a patent is granted. And I will just explain that procedure in a while. And the easiest example that I give to all my students also, or to all my colleagues whenever I try to explain this, is that all of you are academicians over here. Students come and take up admission in your university. Simply the fact that a student has taken up admission in a university does not mean they will get a degree. They have to pass certain examinations. And this is exactly what happens in the case of most of the intellectual property. For example, for trademarks or patents, you apply, you undergo an examination, a particular process, and only upon successful completion of that, a patent will be granted to you. Exactly the same way a student has to undergo examination and then get a degree. And number three is one of my favorites. Unfortunately, we are, or fortunately rather, we are giving a lot of emphasis on patents and on IP awareness, rightly so. But as a society, we have to understand that just because by having more patents does not mean that we have made any progress or we have developed. Those patents have to be commercialized. And a culture of innovation or research fundings, a lot of things are required to make a society, a country truly developed. I will not go into those aspects. Some of them are philosophical, some of them are outside the domain of today's discussion. But suffice to say that simply having patents or simply having an IP culture is not going to make us developed or is not going to make us innovative. We have already been innovative to a considerable extent. But what helps is a plethora of other factors. You need to have investment in research, a culture of research and innovation. You need to have collaborative research, open science. All those features are there, which together go on to make a society more developed. Patent is only one tool. And this is also something very interesting, something which we do every day. Many people think that once a patent is granted, end of the story. That is it. That is all that we have to do. No. A patent can be revoked, can be cancelled, can be invalidated at any point of time. And again, I will go back to my student example. Suppose a student has adopted unfair means or got a degree, or somebody has got a job and later you find that that person got that job or that degree, that qualification by adopting unfair means, by some misrepresentations, by certain illegalities. You will cancel the degree or you will cancel, throw out that person from the job. Likewise, even if a patent is granted to you, but at a later stage, the life of a patent is 20 years. So at any point of time, if it comes known that the patent was wrongly granted, there was a mistake, there was an error made by the patent office, the patent can be revoked, it can be recalled, it can be cancelled. And the related aspect of this is a patent is not the end of journey. You have to commercialize that patent. Again, the parallel with the degree example, just because I have a degree, I have a doctorate, does not mean the end of journey. I still have to get a job. I still have to monetize my qualifications, monetize my research. Likewise, when you get a patent, you write it in your CV, you write it in your biodata, oh, right, I have 100 patents. No use. You have to commercialize those patents. You have to work those inventions. So this is another myth. And one more thing, the last aspect, that the patent is not granted solely to reward innovators. No. A patent, as I said, patent has to be worked. A patent has an important socio-economic function. The idea behind grant of the patent system is that we have to reward innovators. Yes, we have a lot of innovative minds, inventors. We have to reward them. We have to compensate them for their hard work. But equally, we also have to benefit the society. We want that whatever research is conducted, whatever patents are obtained, they are monetized, and they should be used by the industry. As Dr. Siwal pointed out, industrial application is also one of the criteria of grant of a patent. So your patents, your inventions should be used by the industry. And when they're used by the industry to make new machines, to incorporate new technologies, new products, new processes, it leads to job creation. It leads to employment. It needs to rise in living standards. It leads to rise in technological output for the society. So a patent system has a very, very important role to play in the growth and development of a country, in its economic development, in creating jobs. And that is why it is extremely important that you do not stop at just obtaining a patent, but you go a step further. And this is something very, very relevant for academic institutions, something I would perhaps be stressing towards the end of this presentation. You need to have academic industry partnerships, not just to obtain patents and put it on your CV, but to have commercialization of patents, enter into contracts, license your patents. So this is, these are some of the points about which people have certain myths or misconceptions. And I thought that we should probably start by dispelling some of these myths and presenting the facts. Now, as I said, the second aspect with why we are promoting this IP culture, why this 2016 IP policy is putting so much emphasis. Why are we having all these webinars? Why is patent law a hot topic? IP law is a hot topic. Why? And the reason for this is that today, in this present century, this is a knowledge economy. We have big companies in the Western society, in Europe, in US, big pharmaceutical companies, big electronic giants who keep innovating, keep applying for patents. And these patents, the patented products, they are very, very expensive. And back home in our country, for a variety of reasons, although we have some amazingly brilliant mind, we have beautiful minds, innovative minds, but we are not able to monetize that research. We are not able to adopt, if I could say that, adopt the language of the West and answer in that language. We are not able to, because we don't have so much awareness, we're not able to patent our inventions effectively. And the reason is, when we don't do this, when we don't apply for IP protection, when we don't go for patents, our inventions can be copied by anybody. So even if we have brilliant innovations, sometimes our scientists, our researchers, they write articles about it, they share it with the industry freely. There are no contracts, no monetization, and the result is anybody can freely copy. So, and the data, this is why I always present this kind of data. The data with regard to patenting in India leaves a lot of scope for improvement. For example, and this is on the basis of the 2018-2019 report, annual report of the Indian Patent Office, which was released last year in October. They don't have the updated version as yet. So based on the 2018-2019 data, as of 31st March, the year ending, fiscal year ending 31st March 2019, there were 64,686 patents in India which were live, active, in force. They had not expired. The life of a patent is 20 years. That's the monopoly you get. And out of those, the patents owned by Indians were a mere 9,787, or a 15.13%. Less than 16% of the patents in this country are owned by Indians. Indians meaning Indian applicants, which can be universities, which can be companies, which can be big giants like Reliance, or startups, or small and medium-sized enterprises, colleges, research institutions, DRDOs, IITs, total individual innovators. The cumulative patents that were owned by Indians were less than 16% of the total. And in 2018, around a little more than 50,000 patent applications were filed in this country. And how many did Indians file? A little more than 17,000, which is hardly 34, around 34%. That is the filing rate. And so, which means basically why we are doing this, we want to really, really make people aware. Your students, your colleagues, the academicians, the teachers, because they create the future, they create the tomorrow. We want this awareness to spread, that it is important to monetize your research, protect your research, commercialize your research, and patent your research. So, and this is the year, this is not some phenomena of one particular year. So from 2013, 2014, this has been the continuous trend. So you can see the patent, granted patents in total, and patents granted to India, less than 20% for each year. In 2018, 2019, less than 17% patents in India were granted to Indians. Are we maintaining the patent office only for foreign applicants, for foreign companies, big giants? This is something that we have to wonder. And and this is another interesting aspect. As Dr. Siwal said, I litigate these cases every day. Even today, this case that I might just take a break for joining is of Dr. Reddy's laboratories. We were the defendants. And one very unique feature is that you will find the plaintiffs, the person who is filing the case, the patentee, in all of our cases, most of the cases are foreign companies. AstraZeneca, Pfizer, Bayer, Bristol Myers Squibb, Dolby, Interdigital, Philips, Lenovo, all of LGE, all of them, or Nokia, all of them companies based in Europe or US, and all the defendants, generally, especially in the pharmaceutical sector, are Indian companies. We have infringement suits against us, like Netco Pharma, Dr. Reddy's, Cipla, Reliance. And the importance of this is that we have to, instead of simply being defendants, we have to reach a position where we become the patentees and we file cases against others. We sue them for infringing our technology. Unfortunately, that is not happening at the pace at which it should. So this is about the patent trends. But anyway, whenever something is like this, something is so bad, there's always scope for improvement. And that is why the relevance of these kind of webinars, seminars that we conduct, that is why I love interacting with students, because these are the things we need to tell them, and academicians also. And this also brings me to one more fact. When Dr. Siwal was giving my introduction, he mentioned that I have been a student of science. And I did my graduation in chemistry from DU. And I understand Dr. Kiran, the principal, is also a chemist by training, a PhD in chemistry. So, and I'm a patent agent. So one thing that I want to point out, this as a slightly aside from this, the qualifications for becoming a patent agent. Any person who is any citizen of India who is a science or engineering graduate can sit for the patent agent examination. You don't have to be a law graduate. If you have a law qualification, that is a wonderful thing. So when we go for these kind of conferences, we also tell particularly the science faculties, the engineering faculties, the technology faculties, we tell them that please, the young teachers, the young professors who are interested, or the students who are interested, this is an amazing career option, becoming a patent agent. And like with every other career, you have to get in. It requires hard work in the initial stages, but once you are able to hit it, it's a wonderful profession to be in. And any science graduate, BSc, MSc, PhD from any stream, they're eligible. So this is one aspect. Now, okay, and while I was talking about the India filings, like 17%, 18% of the filings are by Indians, and hardly less than 20% of the patents are owned by Indians in India. What about other jurisdictions? We want to compete with China. We want to become a developed country. We want to compete with Japan, Germany. So I selected these 4 jurisdictions. And from the WIPO website, I had data for the patent filings in these jurisdictions. And compared to, now this is the comparison. Patent applications filed in India in 2018, 2019 were a little more than 50,000. In comparison, for in 2018, the annual year, not the fiscal year, China filed more than 15 lakh patents. USA more than almost 6 lakhs, Japan more than 3 lakhs, and Germany 67,000 something. Germany is more comparable to us. But the point is that in Germany, the success rate is more. So like in India, you will file 50,000 applications after the undergoing the examination process, 10 to 15,000 patents will come into being. But in Germany, the system is much more strenuous, stringent, and the success rate is also more. Their quality of examination, the quality of patent agents, the quality of innovation in Germany is extremely high. So compare this, the 4 jurisdictions as compared to where we are. And that is why I say there's a considerable scope for improvement. And this is a step in the right direction. This is the recent changes which Dr. Siwal pointed out, that we are giving a lot of emphasis that educational institutions, academic institutions should take the lead in probably academic industry partnerships and in patent filings. The fees has been reduced by 80%. 80% discounts are now available to academic institutions. So if a normal patent application requires 8,000 rupees to be filed for an academic institution, it will be only rupees 1,600. So this and okay, this we have already discussed. This we can skip for the time being. This is what a granted patent looks like. This is an Indian granted patent, which was granted to one of my earlier clients. I just thought I'll share a screenshot of the same. This is this is the website. It's wonderful. As a practitioner, we have a wonderful interactive IP website, IP filing system. You can log in. It's a very, very smooth system. This is what it looks like. You need to have a login ID and password and digital signatures to actually file a patent application. But this is the public feature. You can see the status of any patent application or granted patent on the website. And so, for example, this patent number, application number, it's a whole process. Just like, again, going back to students, a student has an enrollment number, examination roll number, class roll number. So all the bibliographic data is available for patents also. And this is a PCT application. I'll just come to it in a while. This is a patent cooperation treaty. So as I said in the beginning, you can file an international application, but even after you file an international patent application, the grant of the patent is governed by the country concerned. So I can file an international application in, say, US, China, and India, in 3 countries by the PCT mode, and it will have an international publication date, as you can see. This is an international application published under the Patent Cooperation Treaty. But the final patent which is granted will be examined and granted by the patent offices of India, China, and USA respectively. So the patent would be a territorial right granted by the country concerned, by the patent office concerned, but you can, under the PCT route, you can still file an international application. That's it. It's like in Delhi University, we have a wonderful system. You file a common application and then you go to individual colleges at the time of seeking admission. I'm sorry, I'm taking a lot of parallels from the field of, from the classroom, from students and teachers, but I think that helps me to make a connectivity and explain these concepts. But for the time being, we can skip this PCT. You need not bother about as of now. It's a slightly more complex thing. We can high level concept. But this is a US patent, granted patent, control of plant gene expression. This is how it looks like. So like Mr. Siwal was, Dr. Siwal was saying, prior art, you can see all those prior art searches, field of search, all those things are there. So just give me a second. Just give me a second. Okay. This Dr. Siwal has already talked about. Okay, I'll just take 5 more minutes and I will conclude. This we can skip. Now, this is what these are the type of applications. There are 6 applications. You may concern yourself at the present moment only with the normal application which is filed in India, and I will deal with that. What is the procedure of filing this normal application and who can file? So there are 3 categories of people who can file an application in India. One is the true and first inventor. So for example, if Dr. Ashwini Siwal comes up with an innovation, he can file it in his own name. Or if he's working for DU and by the contract of service that he has, Delhi University, just give me a second. I'll have to take this call. Just give me a second. Hello. Yeah. So if he assigns it to Delhi University will become the, I'm so sorry. Delhi University will become the assignee, the owner, and they will file the application. Or if unfortunately the inventor or dies, the legal representative can file the patent application. So these 3 categories of people can file the patent application. And the criteria of grant, Dr. Siwal has already discussed. There are 5 criteria of grant: novelty, inventive step, industrial applicability, patent eligibility, which is whether you qualify as an invention or not, and disclosure or written description. This is like an answer sheet. This is what I'm going to focus on. I will skip the other parts because Dr. Siwal has already dealt with them in detail. So we can skip this. Now, when you file the last portion, when you file a patent application, what exactly does a patent application contain? And that is right in front of your screens right now. A patent, just like you write a research paper, I'm sure all of your academicians have written those research paper theses. You have a title. You have a title, you have an abstract, which gives an overview of what your paper is about. You have certain drawings, you can have chemical structures, you can have models, and then comes the main crux in a patent application, which is description and enablement and claims. And that is where you actually describe your invention. What is it that you have invented? How is it better than the prior art? How is it better than what already existed? And what is your invention is something which is comprised in the claims. Claims is where you, so there are a series of steps. Just like in a, most of you are from science background, you will understand you write your experiments in your practical book, step by step. So you do this, you do this, you do this. Likewise, claims are where you describe what you have invented step by step. This is where your real invention is. This is where the technical information of the patent is. We can skip the highly technical legal discussion on this aspect, but suffice to say, claims and descriptions is where your heart and soul of the patent application lies. This is what the patent office is going to examine. Now, I'll just have to take a break. I'm so sorry. Shivalji, I'll just come.
Yeah, so sorry for the inconvenience. This is the lawyer's life. He had to leave in between because he has already told us that he may get to go because of his matter which is going to be listed before the lordship. So I think that he has talked sufficient, or he has discussed sufficient of what we needed him to tell us. And Dr. Anuradha, is
Yes,
it fine
sir.
to conclude
Sir,
because the time is also already over?
yes, sir. Yeah, I think it is fine. He has explained the things very
Okay.
clearly.
Just
How to file,
then
how
we will
not to
conclude.
file. It was a wonderful lecture. So,
Okay.
if there is any question, participants kindly go for the question answer session.
Yeah,
You
I
can,
would take up the questions if there are any.
right,
Even on
sir.
his behalf, I am happy to take the questions.
Right, sir. You can unmute yourself, participants, or you can put question in the chat box. Sir, I have a question. Sir, suppose we design something, could we, means it is just a drawing, not the product yet. Could we file patent even then for design?
डिजाइन पे पेटेंट नहीं मिलता डॉक्टर अनुराधा. मैंने आपको बताया था कि कोई ड्रामेटिक आर्टिस्टिक अगर वर्क्स हैं, आर्टिस्टिक वर्क्स है, तो आपको कॉपीराइट प्रोटेक्शन मिलती है. और जब आप डिजाइन किसी आर्टिकल पे अप्लाई करते हैं, अगर आप कोई इंडस्ट्रियल डिजाइन बनाते हैं, तो आपको इंडस्ट्रियल डिजाइन एक्ट में डिजाइन राइट मिलता है.
राइट सर.
पेटेंट नहीं मिलता उस पे.
ट्रेडमार्क वी कैन गेट, राइट? एम आई राइट?
No,
sir, suppose for science students, they just make a design for something or like that, so we cannot file.
वो कोई लोगो, कोई सिंबल, कोई न्यूमरल, कोई लेटर, किसी चीज को इंडिकेट करने के लिए कोई यूज करता है, तो वहां पे वो सब है ऑप्शन आपके पास कि आप ट्रेडमार्क ले लो. लेकिन अगर कोई आर्टिस्टिक वर्क है इन द फॉर्म ऑफ अ पेंटिंग, तो आपको कॉपीराइट मिलेगा. और अगर कोई इंडस्ट्रियल डिजाइन है विच यू अप्लाई ऑन एन आर्टिकल, कोई पैटर्न है, कोई किसी तरह की कॉन्फ़िगरेशन है, शेप है, तो वहां आपको इंडस्ट्रियल डिजाइन एक्ट में राइट मिलेगा, पेटेंट नहीं मिलेगा इसके ऊपर. विक्टर, मैंने आपकी एब्सेंस में आई टुक ओवर एंड we decided to conclude because the time is also over and the question answer session is going on. Okay. So I opened the floor for Q&A, and I also agreed to take questions on your behalf, right? Now you are back. So so in case if there are any questions, anyone may please put questions.
Do you want me to conclude just one slide? I want to present the final.
Yeah, you may do that quickly.
And this is I heard Dr. Siwal was saying this is a lawyer's life, as luck would have it, and this is something very, very practical. One of the reasons things get delayed sometimes, the judge did not have the file, so we prepare, we change our schedule, and we do all these things, and when the matter comes, judge does not have the file. So these things happen sometimes, and the 1 second the matter is over. So I'm so sorry I had to immediately go in between, but I'll just resume the share. So as I was saying, can you see the slide, Dr. Anuradha, Dr. Sival?
Yes, sir, we can see the slide.
Okay, I'll just conclude. I'm so sorry. Uh, so as I was saying, the claims and description is where you actually describe your invention. And you can skip the parts. There are some declarations which you have to give, that I am the true and first inventor, which is a declaration as to inventorship. If you have filed any foreign applications, you have to give those details of foreign applications. So this is what your patent application looks like. It's like the answer sheet. And this is the example that I give to people mostly, that when you want to pass, you sit for an exam, you write an answer sheet, and it goes to the examiner. And the examiner will examine it, and based on how you have performed will decide whether you pass or whether you don't pass. This is exactly what happens in the patent office. This patent application, the complete specification is your answer sheet. It comprises of a title, abstract, drawings. Models are optional. If you want to give a model of your drawing, of your invention, the best method, how to perform the invention, what are your claims, description, describe your invention, and then you declare that this is my work. I am the true and first inventor. There's a form for that, form 5. And these are the foreign applications that I have filed in, say, USA or China. You do all this. This is your answer sheet. This is your complete specification. This goes to the examiner. And after the examiner has examined and decided that, yes, you meet the criteria of grant, you satisfy novelty, you satisfy inventive step, you satisfy industrial applicability, and you are entitled to protection as an invention, they will grant you the patent. This is exactly what happens. There are some separate criteria related to biotechnology innovations. If there are any questions relating to that, I and Dr. Sival can perhaps answer what are the special criteria for biotechnology inventions, because their Biodiversity Act, all those things come into play. Now, this is the slide that I wanted to emphasize on. This is how the procedure proceeds. You file for a patent application, then this patent application is published. Because one of the reasons why we are granting patents is that we want disclosure of innovations. We don't want them to be trade secrets. What is the fun? What is the fun if you keep inventing the same thing over and over again? If Dr. Sival has invented something, it is never published, it never becomes part of public domain, and I reinvent the same thing. It's a waste of effort. It's redundancy. So whatever patent application is filed, it is published. And this publication has to take place within 18 months and of filing date. And after publication of the patent application, okay, just 2 more minutes. After publication of the patent application, there is a possibility that your competitors might oppose your application. That possibility is there, that this application should not be allowed. There has been theft of research, chori hui hai, or that it is not novel, and number of reasons are there. You need not bother about it. That's a totally legal thing. And after that, the application is also examined in the examination stage. So patent application is filed, it is published, and it is examined. Examination is where the patent office, the examiner, they're technically qualified people. They check your patent application, they check your invention, and they decide whether you meet the criteria of grant or not. And if you meet the criteria of grant, the patent will be granted to you. And unlike examinations that you have in universities, it is a very special, unique feature. They create an examination report of objections, and they give you a chance to answer those objections. So kind of re-evaluation takes place. Need not bother for this introductory lecture on the nitty-gritties of those. So patent application is filed, it is published, examined, and the application is granted. And that grant is also published. And the detailed procedure is something like this. As a very preliminary level, this need not concern you. I've already explained this procedure. And this is what happens when you file a patent application, and usually it takes about 2 years, 2 to 2.5 years to get a patent, unless you have some special concessions available to you as a startup or academic institutions, in which case the timeline is reduced. So this was about patents, how they work in India, the procedure for working of the same. And I'm really sorry for that break I had to take in between. And thank you, Dr. Anuradha ji.
Thank you so much, sir. I request the participants to put your questions in the chat box, or you can unmute yourself if there is any question. Though, sir, your slides were really self-explanatory, and you have explained so well that how to file a patent. It is like very clear to all of us. If there is any question, if there will be any question in future, I will send you to mail, and I hope you will answer those queries. Right?
Sure.
And now I invite my beloved friend, Mrs. Anchal, for formal vote of thanks.
Thank you, Anuradha ma'am. Am I audible?
Yes, you are audible.
Okay, thank you. A very good afternoon to one and all. It's my privilege to propose the vote of thanks on this online national level seminar on IPR organized by IQAC under the Paramar scheme of UGC for the Mentee institutes. On behalf of whole M.D.S.D Girls College, I extend a hearty vote of thanks to our honorable speakers, Dr. Ashwini Siwal and Dr. Victor Vaibhav Tandon, for their thought-provoking and informative addresses on patent. I also like to thank our beloved and worthy principal ma'am, Dr. Kiran Angra, Assessment and Accreditation Ambassador, Paramarsh. Her exemplary vision is the foundation of today's event. My sincere gratitude goes to our organizing team, Dr. Anuradha and Mrs. Nishu Bansal, for their hard work and dedication. A special thanks to all the participants for their active participation and making this program more successful. Thank you, everyone, and have a nice day ahead.
Thank you so much, Anchal. I request you to send feedback link also in the chat box.
Okay, ma'am.
Thank you.
Thank you so much, sir, for your gracious presence. Yes, sir, you can leave now, and candidates, you can fill the feedback form, and after that you can leave. And we'll meet again at 3 o'clock in the afternoon. And dear participants, it is a humble request to join early too. And you can fill the feedback form, and after that you can leave the meeting. Meeting is open for next 10 to 15 minutes.